we're going to bring on Immaculate. We want to talk about the hearing on Monday, kind of the fallout from that. I have some questions. I have some opinions. I want to hear your opinions. I want to hear his opinions. We haven't talked about it very much, like at all.
Nope.
So this is, you're going to hear our opinions for the first time. And then I know there was a big day on the Hill where a bunch of ADs and autonomous people and I don't know. Immaculate can tell us all about that. So anyway, we're going to bring him on. Immaculate, great for you to come back on the Big Mountain. So glad you were willing to do this again. I know we were kind of hoping the next time we talked was going to be
settlement would be finalized.
Yes, a finalized settlement was going to happen, but we still have to wait a little bit longer for that. But hey, thanks for joining us again.
Absolutely. And I can tell you guys right now, you look great on YouTube. So good job to your producer there. I'm giving you some direct feedback.
Thank you.
We're YouTube beautiful.
He's working overtime to make us look this good.
Sounds good. And yeah, we didn't get a final ending, I guess you could say, to the House situation, but it's starting to parallel the preliminary approval situation that happened. And as far as what happened on the Hill, your guess is as good as mine. They kept it pretty hush so far.
Yeah, hopefully we'll get some more news on that. Let's start with, I definitely want to hear where you're at with some of the congressional stuff that did come up in the hearing. And you know what? I got to get off my my phone real quick.
Okay.
Because I see we're. Oh, I'm not. Wait a minute. Sorry, Mike. Give me 1 second.
You're good.
My daughter's home from dance class, which means she's burning all of my Wi-Fi, and then people can't see live shows. But anyway, so I want to get into the hearing first, and then of course, maybe we'll get a little bit more into the congressional stuff that's happening. So a couple topics that I want to hit, and then please, you guys, have at it with whatever you want to bring up as well. One of them, focusing a little bit on roster limits. And again, I didn't hear the discussion. This is from different reporters. Dellinger did a lot. I saw a USA article. I can't remember all the other reporters that I was reading up on, but I tried to, not just rely on one person. But roster limits was one item. Another one was really concerned about kind of the future athletes that aren't, the judge was concerned about the future athletes that are not in the NCAA right now. I think she talked about a 10-year-old, whatchamacallit,
lacrosse player.
Yeah, anybody. Yeah. And then, of course, we'll get to the congressional action. So I want to start with the roster limits, because to me, I thought this one was interesting, and I thought she actually brought up some good points. One of them had to do with grandfathering in current athletes and current scholarship players. Another one was kind of that phasing in of roster limits. So Judge Wilkins said it is not that, in terms of the grandfathering piece, she said it's really not that many people, and it's really not that much money. The defendant attorney here, which is the NCAA, said that roster limits are a part of the settlement and were not reached arbitrarily. He said that this would affect a small number of folks rather than hundreds of thousands covered by the settlement. And then, of course, she talked about looking at kind of phasing in the roster limits, not going from where we are today down dramatically in 1 year. And I don't think she necessarily defined what the phasing was. So I'll throw it to you first, Immaculate. What were your thoughts kind of on the discussions and what you were able to read up on in terms of both the grandfathering in of current scholarship players and then also, maybe phasing in these lower roster limits?
Well, if I could wrap it up in one word, I think the one word would be confusion. I'm actually confused by it. At one point, she made it very clear that this is nothing to do with Title IX. That Title IX has nothing to do with this. Yet if one looks at Title IX and what Title IX says, it's all about protecting opportunities. And that's exactly what it sounds like she's trying to do. She's trying to protect roster spots so that kids aren't getting cut. And she's worried about future kids getting grandfathered in, which the way I understood this whole settlement is it's paying out for past NIL value. And the future is all about having a new setup, a new way of doing business to pay future kids. So I don't quite understand either reference, Now, I'm not a legal expert, so I'm not trying to be like, well, it doesn't make sense. I'm sure it does. It's just, at first, it kind of confuses me because in terms of roster sizes, I mean, if we're going to start treating this like a business and you have to all of a sudden take on this cost of a 20% boost in your cost, guess what? You're probably going to have to watch how many employees you have. You have to watch how many people you have on. And so during that process, if they came to these roster numbers, I don't know if they're, leaning in one direction or not. It just kind of seemed, okay, so this is Title IX, or I don't know. Maybe you guys got a little bit better understanding of that, but that was my first impression, is just kind of confusion as to why this was holding the thing up. This isn't new. This could have been brought up in preliminary.
Yeah.
Well, that leads me into what exactly my follow-up question for you is going to be, Immaculate, is how basically the overall question is, how confident are you feeling that the settlement's actually going to get done and approved as it is, or if it's going to require major um concessions or changes? And if that were to happen, would both sides agree? And the reason I ask that is I think a lot of people were very confident going into this hearing that, this was just the final kind of step. But she brought up some major considerations that you just brought up: the roster limits, the grandfathering. And I think I took it less as a Title IX issue, because I think she was very clear she does not see this as Title IX whatsoever. But the future party considerations, basically those future athletes don't have a seat at the table in this settlement, but the NCAA is looking to set a framework of rules that are supposed to go out 10 years, basically. That this framework will last 10 years. We know NCAA athletes, there could be 7-year-olds right now that would be affected by this. They can start college sports at age 17, or at least sign agreements to play at a certain school. So she seemed to have some definitely seemed to be hung up on the future players consideration, and do they have a seat at the table? And at one point, one of the NCAA lawyer responded and said, this is a huge part of the settlement, is setting up this framework over the next 10 years. And if we're not going to do that, if we don't get that certainty, I think he used certainty a bunch of times over the next 10 years, then we don't have a deal. Like, maybe we don't want to participate in this deal. So, Immaculate, has anything changed in your confidence level? I think I'm just, you and I go back and forth on Twitter. I'm usually more pessimistic than you on both the court case and the legislation piece. Do you feel as confident now today as you did before the hearing, as far as if the settlement is going to get approved?
Well, if we're the spectrum, I actually think I got pulled in your direction a little bit. I get maybe why in preliminary, you're having your debates and your objections, and this is what we need you to work on, and you get that done. And then to do it again in final, it's like, okay, these are the two things that really held you up, that they were part of the deal then too. So who in the objectors really got to her? Or is she just trying to look, like, hey, I didn't just streamline this through? I don't know. She's essentially the authority. She did Alston. She did O'Bannon.
Yep.
If there's ever been a time when that term should be used for one person, it's this right here. So,
and her decision, I'm sorry to interrupt you, but
no, go ahead.
Decision was upheld by the U.S. Supreme Court. So she, like you said, she is the subject matter authority.
Yeah. So I think that to some degree, like, this is her legacy too. So that could be part of it. I don't want to, say it's this or that, because I don't know. I'm not in her head. But it's got me wondering a little bit, because, as you're saying, from all reports of it, they were a little thrown off by not necessarily that it got held up, but what held it up. And you even had the attorney for the plaintiffs, one of them, Burman, really kind of freaking out about this. As you alluded to earlier, actually saying, if we don't get this passed, Congress could pass something and then this whole thing goes away. So I know we've gone back and forth on that, and I'm just, a guy on the internet, but that guy is dialed in. And for him to say that makes me wonder too.
Yeah. I mean, It's interesting. You bring up the connection between the grandfathering and the phasing in of the roster limits and kind of the Title IX, right? The opportunity, the protection, however you want to. Like on the surface, I look at the grandfathering and I say, well, that again, putting Title IX aside, which she said this isn't a Title IX case.
Yeah.
So I'm like, okay, not a Title IX case. I'm going to listen to her on that. And then I say, well, the grandfathering to me makes complete sense. Like, but maybe I'm being too nice, which is not often said about me. But like, you know, a kid in scholarship players right now, um, again, maybe I'm being too nice,
Yeah.
shouldn't lose their scholarship because of this case. I do feel like, and maybe that's where you get the phasing in, if you will, of roster limits. To me, it's not one or the other necessarily. Or it's not doing both, it's doing one or the other. And if you're going to do a grandfathering, then there is a bit of a phasing in of roster limits because you're gonna exempt these current athletes that have scholarships potentially from the new limit. So there is a phase in of these new roster limits because you have grandfathering. Not being in the courtroom, I'm not sure if she was talking about them in together or if she literally meant I want grandfathering and I want you to look at the phasing of roster limits. I'm not 100% sure where she was coming at with that.
I'm not sure that she used the grandfathering term. I think she said phasing in, and then other people on Twitter were like, yeah, we've been talking about grandfathering.
Okay.
What's your take on that, Immaculate?
That's a part of that too. I think you make a good point, is that I don't think any one of us three watched this thing live, and we're taking kind of secondhand reporting from some reporters talking about this, and some of those are just reporting on what other reporters had to say. So
yeah.
We could be losing a little bit in translation, so to speak. But just the generalness of it, of like, I get the feelings of it and the want to desire, but she said herself, this is not a Title IX case, which means This is not a case about opportunities. Right. That's if there's one word to define Title IX, it's opportunities. And so I don't honestly quite know exactly how to diagnose that. Like I said, this just might be a legacy move, right? Like, she needed to find something else in there to hold it up a little bit, make them work a little bit more in there, using the opportunity. And maybe that's all this really is. We'll find out.
True. Well, let's talk a little bit more then about, Steve had brought it up, kind of that future athlete piece. It definitely seemed to get in the reporting. This was one she was really focusing on. And I just a couple notes I have here. The settlement incorporates binding athletes, again, that aren't even in college yet. And the settlement is for a 10-year deal. During the discussions, the judge and attorneys discussed, possibly excluding athletes from the settlement and creating what was reported to be this new class every year. So every, year one is class one, year two is class two. That seems like an administrative nightmare. And I'm not sure who's going to look at that. But anyway, I guess that was kind of a shooting from the hip idea that they were talking about in the courtroom. But as Steve, you pointed out, the NCAA attorneys, like, this is all about stability. Like, this settlement is it's not a one-legged stool. Like, we've settled with all these different things, and this piece is about 10 years of stability for the NCAA and its members. And without that, there would not be a deal per the NCAA attorney. And that makes total sense. Like, they need stability. That's why they're even, frankly, at the table, I would think. Like, help us get to a new reality. And we'll get into some of the congressional pieces that maybe are needed to help form that as well. But I mean, what are your thoughts there in terms of, they're clearly paying off the wrongs of the past. That's this, what is it, millions, billions, whatever the heck it is, this huge number of past athletes. So paying off the wrongs, but they're also looking for stability into the future, thus this 10-year kind of look ahead. What are your thoughts on that, Immaculate?
Yeah, I just encouraged what you just said. I think the past number is 2.8 billion.
That's what I was thinking. That. Okay.
Yep.
Thank you.
2.8 billion. And the future to me is, I was under the impression that this is about them being able to sign kids to NIL contracts. This is where you sign a contract for a certain amount, you're getting paid for your value. Whereas in the past, there's certain people like Livy Dunn who are not going to get paid their value. I've referred to as a unicorn. Like, you're just too big. You're not going to get your value in a class action suit. You may have to do that afterwards on your own.
Right.
So it's kind of just generalizing everyone in the past. In the future, these kids are going to be able to get a little bit more of their value. But if you're going to hold these athletic departments accountable to 20 to 22% of their revenue going towards this, you have to allow them to control how many they're paying that to. Like they have to run it like a business. That's what you're expecting them to do. So you wouldn't go to a company, a corporation, say, you can't go below this number of employees. So it's kind of wanting to have your cake and eat it too a bit. But hey, when you're the sole authority in the moment, I guess you can have your cake and eat it too if you decide you want to. So yeah, I just think I think it's largely agreed upon. They'll make some small changes in that regard to, make it look like she got this done.
Yeah.
And they'll probably go forward.
So Immaculate, well, first, I love following you on Twitter with this stuff, because even when you and I have different perspectives on something, just the way you dig into it and the analysis and how all the different parts work together, I think something you and I agree upon is the settlement. I have my problems with the settlement. I would say my problem with it is they're trying to use a settlement of past grievances to create a framework for the future, and where I think you and I both agree that even if this settlement goes through Congress, I know we're going to get to that topic here soon.
Go for it.
But Congress is going to have to step in, whether it's an antitrust exemption and other legislation, whatever. So, both of those things are kind of going on at one time with the hearings and all that. And I was following your Twitter, and you were basically taking things that were said in the courtroom and highlighting those. Okay, how are those going to affect the possible legislation? There was a couple things that you highlighted. So do you want to just kind of talk about that? Let's just assume the settlement, maybe there's some changes, but we move forward with a settlement. How do you think this is going to play out, transitioning from, okay, a settlement creates a framework, but now we need Congress to step in and actually add some power, some strength to solidify it? Do you those are kind of happening at the same time? Do you see them playing off each other?
Yeah, and I actually think I was a little bit wrong in the past. I thought that they were playing maybe in coordination, but I think maybe the A4 knew that this wasn't going to pass right away. And so today, instead of having a victory, and I'm using air quotes here, you can't see, a victory to show forth to there at Congress today, they have an unknown. They had worry. They had actual people who were there voicing concern. So that's what they had in their hand to go and speak with these congressionals. And I might actually say that might actually be more powerful.
Mm-hmm.
So, might have got that one wrong, but, and they certainly kept that thing under wraps today. That was for those we want here, and only that. I mean, you had I know like the Texas delegation themselves was the AD, head coach for football and basketball. I think there's at least 2 students, and there were some other coaches that went, I think it was 10 people total. So you take that by 60, 70 schools. That was one heck of a gathering, and we don't really know what happened. So I think that they probably were in there saying, hey, look, this thing isn't for sure. This thing isn't for certain. They're trying to say, we have to have this many more in the future. We can't do this. We need help. I do think eventually Congress will act. I have no idea how that's going to look exactly, but they're going to have to. It's kind of one of those too big to fail situations.
So it sounds like what you're saying is they can leverage this uncertainty of the settlement may not get approved, or we may need to make changes that will still leave some uncertainty. They can leverage. You think they'll be able to leverage that into negotiating for legislation from Congress that they want to see?
Well, remember, a lot of these schools, they're public schools. You've got states involved with them. You've got these congressionals involved with them. You have federal aid. You have federal research dollars, which is also under fire right now too. So there's a lot of worries going at these guys from all directions. This is one of those situations that a lot of these schools have to be looking at this and saying, our future in college sports is not certain right now. And as much as we might think, well, it's just sports, I think it's a pretty big deal to people who go to these schools, wouldn't you think? And every single one of those guys and ladies and women in those positions in Congress, they all graduated from somewhere. I'd say 99% of them. So they're all connected and tied in with this too. So I do think eventually they will come to some kind of an agreement. Like Cruz, everyone talks about Cruz as the author for the one in the Senate, but it's also Booker. Like, it's not just a Republican thing. And I think that's kind of on reporters, you know how this works, both sides that go with and whatnot, and that's fine. But just to kind of be clear to people, it's not just Cruz, it's Cruz and Booker. So it is in the Senate, at least, bipartisan. And I think you have some folks in the House who are just trying to use it to gain a few pandering points for their constituents right now.
Well, two more things I want to ask you, then we'll let you go.
Okay.
So we try to keep you about 30. I want to go back to Burman. I mean, it kind of wraps into all of this, and I'm not sure if I got your, we talked about it, but I don't know if I got your opinion on it. And then I just want to do a round between the three of us of where we think things are headed and kind of wrap it up. But to go back to Burman, I mean, you mentioned very focused, I think, early on here, bringing up that, hey, Congress may do something. And I think Cruz's bill was brought up, from what I read, multiple times in this hearing. So clearly there was a worry there, at least it would appear, reading what I was able to glean out of things, where they're worried that a bill could come in. And I think they at one point said the NCAA could get complete immunity. And, maybe they're, on the other side of it, you just talked about how they're maybe selling it to the politicians. Was this maybe a way to sell it to the judge to try and get her to move quicker? Or what do you think the reason was that early on they were focused on this threat of, congressional action?
Well, the first report I saw about that was a direct quote, in quotes. And it was Burman saying, if we don't get this thing done today, there's a good chance this thing passes through Congress and we don't get any of this. Now, to most people, it's like, oh, that means the kids don't get paid. Well, to that man, it means he doesn't get paid. This is class action. And these guys have put in hours of work on this for years. And if you remember, he was also part of, he's either Alston or Bannon. I don't know which one. But this man has been just about as involved with this as the judge has. And we're just, we're some guys just out here talking about it. We can have differences of opinion on what we think Congress is going to do. But when that man says he's worried that Congress might pass something before this gets finalized, which, how long did it take the preliminary? A month? So he's kind of saying that there's a chance, at least, people could take seriously, that Congress could pass something in the next month. I don't know if that's true or not.
Right.
But that man certainly believes there's a chance and that he might not get paid because of it.
Or at least he thinks there's enough of a threat that he can use it.
Right. Or yeah. But she shut that down pretty quick, I guess. It was kind of like a, what does that have to do with me thing?
Yes.
Yeah. So,
Right. But it was interesting that it was a talking point that apparently came up throughout the hearing. I don't know if it was brought up by some of the other people that were speaking, the objectors, or how it came up. But again, they said it came up multiple times.
And I think really, I took it as he's saying that because a class action lawsuit like this is where this is how all the small people, all the little people band together to get something. And this is the way they're going to get something. If we go to the legislation route, all these small people over the last 20 something years, the swimmers, the gymnasts, the divers, whatever, they may not get diddly squats.
Sure.
Because the legislation is going to be focused on, football and basketball that make all the money.
Right.
This class action suit is where we can take care of the small people. And if we don't do that now, they may never get taken care of.
Right. All right. Well, we're going to let you go first here, Immaculate. I mean, Judge Wilkins said that, she would like the parties to get together, talk about these couple main questions she raised, work something out if they can. And I agree with you. You said earlier, is this her just trying to, kind of make a tweak so that it looks like, she had an impact here? And I'm not saying that, to judge her, but judges, they do good work and they want to be impactful. And so, yeah, I think she wants to see a change just so from a public outsider perspective, she's looking like she's doing her job, right? So be that as it may, she said, don't quote me, but she thinks this looks like potentially a good settlement if some of these things can get worked out. So she said, you got 1 week, attorneys, figure these couple things out, and maybe we'll, get her to give a oral, or I don't know what she'll do, written judgment order on this. So put everybody on the spot, because we're so kind, we'll put our guest on the spot first. What do you think happens here? And timeline, I'm not gonna, I hate timeline stuff because everybody says, oh, you were wrong on timeline, but eventually, whether it's in a week or 2 or a month, whatever the hell it takes, what do you think's gonna happen? A couple little tweaks and she'll approve it, or where are we at here, Immaculate?
I think they have to come up with something, right? If you're a judge, like, she felt strong enough about it to use her position to do that. One could argue one way or another whether it was right to do or not. It doesn't really matter. It's her position to do that. So I think when she's calling for that, you better do something. If you come back there with nothing, you're daring her to turn you away. Yes. So there will be something. It really comes down to how big. I guess, I don't know, some small tweaks. Because like I said, she's without doing Title IX, but yet doing opportunistic stuff. She's kind of diving into opening up the door for Title IX claims, in my opinion. So it's a little dangerous too. A couple weeks probably. I don't know if they could just pop that out in a week, but I would say at least within a month, and especially if they are worried about whatever Congress is working out. I guess we'll see tomorrow. I guess we're going to hear more about what happened today on the Hill. But yeah, I think, a couple weeks, they'll tweak a couple things. Now, if you remember the last time in the preliminaries, and I'll end it with this, there was some disturbance within the defendants. The NCAA lawyers kind of threw some curveballs, and the conference's lawyers, they weren't really on the same page. So I kind of wonder if the conferences now might then make the same play and say, we're the ones that are going to be paying this going forward in the future, not the NCAA. The NCAA is just making good on their past. Mm-hmm. The NCAA doesn't speak for us in this. So that, if I was going to say watch for a curveball, it would be that this affects the conferences more going forward than it does the NCAA.
Great point. You want to go? You want me to go?
I'll go.
Go.
Okay. So again, I've been the pessimist in both this case and the legislation. I've thought from the beginning, the one of the major problems with this settlement, how they were trying to use it, is again that they're settling past grievances with a future framework. And I always thought that was the fatal flaw in this settlement. Mm-hmm. And I forget her name, but Judge Wilkins. It seems like we're at 0 hour. We're at the 12th hour. We're at the end, and she brings up that main argument of the future athletes do not have a seat at the table. Mm-hmm. You are asking us to subject the next 10 years of athletes to this settlement so that you can pay off for wrongs that you did in the past. Now you want to do basically antitrust violations to the next 10 years of student athletes, and use this settlement as a mechanism to do that. But those future athletes do not have representation at all. And so I always thought that was the fatal flaw. She seems to think now, how far is she going to push that? That's the thing that we don't know. Because my take from the NCAA from the lawyers was, and from the A4, the Power 4 or A5, whatever, was that if they don't have that certainty going forward those next 10 years, there's no deal. The settlement's off.
Right.
So I came into this thinking, 80-20 would get approved. After that hearing, I'm back to 50-50. I'm more pessimistic than ever, because I think there are some fatal flaws in what they're trying to do. So we'll see.
Okay, so here's where I'm at.
Okay.
It's a settlement. Y'all, everyone's going to be paying all around.
Mm-hmm.
And I mean, I don't see she has to approve this with the 10-year thing, in my opinion. That's we can disagree, Steve.
Yeah.
I mean, the NCAA will walk away if they change that. There is no settlement. To your point.
Yeah.
So to me, I mean, I know she's bringing it up, but I don't know what the answer is. She either has to approve it or deny it based on what it is. And she's saying and I've read that. I think this is a good settlement, but don't quote me. I've read that differently. Like, I don't think it was as cut and dry as some people are reporting it to be. I think it's a good settlement if you can make these changes. So I hear what you're saying on that future athlete thing. Mm-hmm. That is absolutely, for me, the biggest sticky wicket. I think she'll get there because I think, again, you're at the final hour. Like, the settlement's made, the NCAA and the A5, they got to get something out of this. That's what they're getting. It's a settlement. Yeah. So I personally, I get what you're saying. I get the antitrust. I hear everything you said, Steve. Mm-hmm. But I'm not as pessimistic as you that there's still going to be a settlement. And I think they'll twinkle with the grandfathering in type of thing. I'm not sure if they're going to, whether they're going to call it phasing in or grandfathering in of the current athlete. I don't know what they're going to do. They'll tweak that a little bit, and she'll be okay with that, I think. So I'm an easy 80-20 this sucker goes.
Can I poo-poo on you a little?
I expect you to.
Okay. So the reason why one of the reasons I'm more pessimistic. So we talked about it. She had the O'Bannon case. She had the Alston case. Alston was upheld. That was an antitrust case. And so is this. And she's been clear. It's not a Title IX case. This is an antitrust case. And she had it upheld. She knows what she needs to do to basically, she knows what the Supreme Court's
going to allow.
Exactly. Yeah. And the problem with this case, if she allows it, all it takes is next year, one new student, this athlete who's not represented, to sue, and this entire settlement could be easily overturned or put on hold or nullified because it is an antitrust. There's no remedy in it for those antitrust problems for future students. So I think that's why she's trying to have them fix it, because she believes this is a major part of it, of the settlement actually lasting and not being overturned. This needs to be done. I think she wants this change to be done, but I think the problem is the plaintiffs are not going to. They're going to say no.
Well, that's where I'm at. I'm with the plaintiffs, which is where I'm usually at. Right. And you and Immaculate are smarter with these two things than I am.
Well, it's not
so. I want to give Immaculate the final word.
Okay.
He heard what we had to say, and I want to see if he has any comments on our two opinions.
Immaculate, like you, loves when I poo-poo on things.
Okay, all right. Any final comments, Immaculate?
I think Steve got me down to 70-30.
Okay, all right.
I think I wish I could go higher than that. I've been much higher than that. I think I was higher than 80-20. I was pretty much like 90-10 or more.
Yeah.
And it just kind of seems like, how does one say that this isn't Title IX, yet dive into things that are Title IX? So it just, I don't know. And like I said, I think the conferences might be the ones that maybe put some brakes on this thing. They're certainly the ones that were talking with Congress today. So we'll see. Yeah, I think you guys got good points. I think largely she does want to get it done. I think largely they want to get done. There's over 300,000 plaintiffs in this thing that are for it. The objectors have obviously done a pretty good job of making her think about the future. So well done to the advocates on that side of things. They got her thinking, and that's their job. But we got multiple vectors to follow on this thing. So, and if it doesn't happen, I'm not saying because she says no. I mean, maybe because something outside of this happens. So we'll see. But 70-30 for now.
Perfect. Hey, we appreciate you coming back on. I know we were hoping for a finalization, but next time we have you on, hopefully not too far from now, we'll have at least a finalization of this. We'll have a lot to talk about one way or the other. One of us can gloat. I'm at 80-20. Steve's at 50-50, Mr. Pessimist. But anyway, hey, thanks so much for joining us again, Immaculate.
Appreciate it, guys. Always fun chatting with you and look forward to doing it again.
Sounds good.
Thank you.
I'm going to give him
Take
this.
care, guys.